NACDL is the association of the nation's criminal defense bar.
Welcome to Protecting the Right to a Speedy Trial Amid Current Court Closures and Reopenings. I'm Monica Milton, Public Defense Counsel for the National Association of Criminal Defense Lawyers. This webinar is being conducted as a part of the Justice for All Strengthening the Sixth Amendment grant. Partnering with NACDL on this webinar and this grant is the Association of Prosecuting Attorneys, the National Center for State Courts, and Research Triangle Institute International. This webinar is supported by grant number 2019 YABX K001, awarded by the Bureau of Justice Assistance. BJA is a component of the Office of Justice Programs. Points of view or opinions in this webinar are those of the speakers and do not necessarily represent the official position or the policies of the U.S. Department of Justice. With that said, I want to welcome you to our program. I'm going to introduce our panelists and our moderator. We have moderator Professor Andrea Roth from UC Berkeley, Judge Trina Thompson, Superior Court Judge in Alameda County, California, Reid, Regional Manager of the State Public Defender of Wisconsin, Jeffrey Howes, First Assistant District Attorney for Multnomah County, Oregon. And with that said, I'll let Professor Roth go ahead and open her slides.
Great. So I'm really excited to be a part of this, and I know we want to hear from our speakers, so I'll be really brief and just setting the stage here. This is a photograph from 1918 in San Francisco where certain court proceedings were outside, which there are many issues with that being a possible solution this time around that we may hear about. But let me just start with the language of the Sixth Amendment that all of you are surely familiar with, but just to point out that the fact that we have a right to a speedy trial is counterbalanced against these other rights. And so at the same time that we want to make sure that criminal defendants get their day in court within a reasonable amount of time, we also have to make sure that the trial is public, that jury selection works, and fair cross-section and all those requirements, that the defendant has a right to be confronted with the witnesses against them, has the ability to subpoena witnesses, and has a meaningful ability to work with their lawyer. And so if those rights are not secured by the processes we have, then it might butt up against the ability to have a trial within a certain amount of time. And of course, that's what we're facing now. Just wanted to point out what the Supreme Court's test is for determining what a speedy trial violation is. And again, for most of you, this will be a review. But it's not a bright line rule in the sense of, anything more than 5 years is a violation. Instead, the Supreme Court has said, and this is still good law, that you have to look to various factors. Those factors are first the length of the delay, which is not dispositive, but which matters. And so 5 years is worse than 6 months. The reason for delay, which the Supreme Court essentially is talking about the government's justification for delay. They did say that neutral reasons such as court backlogs, if they are the result of negligence, could go against the government in that sense. But it's really about, are there good reasons for the delay on the part of the government? Then, did the defendant make a timely and sincere demand for a speedy trial? This is something that's unusual compared to the other rights that seem to be a little bit more automatic. Here, you've got to show that you actually want a speedy trial, in part because it's one of the rights that, sometimes is to the benefit of the government rather than the defendant. It may be that the defendant is the one who is seeking delay for various convenience or strategy reasons. And then finally, prejudice to the defendant. Did the delay prejudice the defendant? And so determination of prejudice is actually within the definition of a speedy trial violation. What type of prejudice would there be? This is sort of why the speedy trial right can be extremely critical to a defendant. First is if they are incarcerated. Every day matters. And so if you are out on PR before trial, then the fact that you have to wait is less prejudicial. anxiety and concern. Obviously, even if you are not incarcerated, the fact that you have a case hanging over your head is a major issue in your life. And so there's always a reason to have a timely resolution of the claim. And of course, for victims and for the public as well, they have a stake in all of this. And then finally, an impaired trial defense. So it could be, for the same reasons we have statutes of limitations, if you don't have a speedy trial, your witnesses could die or move away, their memories could fade. It can be more difficult for a factually innocent defendant to launch a meritorious defense as time proceeds. So those are some of the things that you need to consider. It's still a multi-factored test in that way. Just wanted to point out that both under the federal law and also many states, there's also a statutory right to a speedy trial that doesn't necessarily have dismissal as the only remedy in the way that it pretty much is under the constitutional test. But it's more of a bright line rule in terms of time. So for example, in the federal system, it's 70 days from the date of the information or indictment or the initial appearance. But the time can be told in the ends of justice. And so even though it's a bright line rule, federal judges have a lot of discretion in tolling the time or in excluding time from the calculation of the 70 days. And that's in the federal rules as well. The court can dismiss, doesn't have to dismiss an indictment for failing to bring the defendant to trial without unnecessary delay. And then I know not everybody's from California, but just to be clear, under state statutes and constitutions, you also might have a bright line rule like a 60-day requirement in California that has been told recently because of the pandemics, but now we're seeing actual in-person trials. And even state constitutions, for example, which have typically been construed by state courts to require some showing of prejudice. Let me stop the share there and jump in right away to our panelists. And so one question that I'd like to start out with is to hear, perhaps starting with Judge Thompson, what innovations or creative solutions have been followed in your jurisdiction to facilitate in-person, socially distanced jury trials during the pandemic? So if we could just hear what's going on in your jurisdiction. So Judge Thompson, do you want to start us off?
Certainly. Thank you for that question, and thank you for the invitation to be part of this panel. In Alameda County, our civil department has held several trials remotely, and they've been quite successful. In civil trials, of course, the plaintiff's attorneys can provide additional resources. On the criminal side, that luxury doesn't exist, but we have been able to conduct criminal trials. In my department and on in our courthouse at the Renee C. Davidson Courthouse in Oakland, we will meet with one another. A floor is dedicated to one trial. So the parties may be in one department and the deliberation will be utilized in another department. So the jury will use another department to deliberate where they're sequestered away from the other parties. For social distancing purposes, we don't use some of the other courtrooms, and if we do, it's with a limited capacity because the clerk or the court reporter or other court ancillary staff may need that space for social distancing purposes. We have seating that is clearly marked where people can sit, and then the social distance of a circumference of 6 feet, not 6 feet apart from each other, but the 6-foot circle. And there's plexiglass where the witness will be testifying so that people can actually see the witness. The plexiglass covers one side of the judge's bench, the front for the court reporter, and the side for the jurors. For defense attorneys and prosecution, they have tables that are now positioned differently, perpendicularly from each other, as opposed to horizontally the way it was previously, so that they are somewhat facing each other, but they have the required distance. One of the suggestions I made in the cases that I have, because I wanted to make sure we could see people when they were testifying, was to use face shields. And face shields do inhibit somewhat being able to hear, but it will help the court reporter because they need to see the person while they're testifying. And then the person can keep their mask on until such time that they need to start testifying, and they can remove it and place the face shield, and that becomes their property after that. So those are some of the accommodations. We also have one way in and one way out. So for our stairwell to go up, you go one way; to go down, you use the adjacent stairwell, so people are not congested. And our elevators only have the capacity of 4 people at a time.
Thank you, Judge. Jeffrey, do you want to tell us a little bit about what's going on in Oregon?
Sure, I'm happy to. And thanks to everyone for having me also. And for those that are wondering, I'm in Portland and it is not ablaze. So we are all safe and as happy as one could be. We've had 2 successful criminal jury trials since the pandemic began, and that was pretty early on, around the 1st of May. And our process mirrored a lot of what Judge Thompson was just talking about. Socially distanced jurors in the back of the room and in the jury box, with the litigants at the table spread apart. Judge and clerk and witness would be up in the witness stand. We did that out of necessity, and we'll get into this a little later, I imagine, but our rule is such that if a criminal defendant is in custody, that custody can only last a maximum of 180 days, and at that point then the defendant would be released by operation of law. And so both of those trials occurred when the defendant's time in custody had nearly lapsed. We were at about the 178th day on both. I gotta say that after those 2 trials, the appetite for more waned. While they were successful in that they went to verdict, I think there was enough hesitation by our presiding judge and our chief criminal judge about the process and about due process that we've sort of taken other steps. Our legislature acted and sort of inserted an emergency clause into our speedy trial rules to allow for the retention of certain defendants if they were deemed to be sort of a clear and present danger if they were to be released. But more simply were released from custody. In terms of practicalities, we had, in order to ensure a public trial, our court uses WebEx, and we piped WebEx into a second courtroom so that the public could attend if they so chose. And deliberations then, and the jury would retire together to an altogether separate courtroom so that they could be socially distanced, and even before they deliberated, they could be together and sort of sequestered. I don't know what's going to happen in the future. We've got the plans, sort of like Judge Thompson described in her courthouse, to hold trials, but I think everyone in Portland and Multnomah County is kind of holding their breath and waiting to see if we're going to relax our restrictions, both those in place by the court and in place by the governor. We're still in what our governor refers to as phase 1 in Multnomah County. We still have a fairly high case count of COVID-19 and a high positivity rate. So we're not moving anywhere soon, but we showed that we can do it. And I think that was an important first step. But we haven't done any actual trials since the first part of May.
All right, thank you, Jeffrey. Ryan, could you tell us what's going on in Wisconsin from a defense attorney's perspective?
Yeah, good afternoon. Again, thank you so much for inviting me and having me on this panel. In Wisconsin, it's kind of county by county. Up where I am in northwestern Wisconsin, you have to submit plans to have jury trials and in-person court hearings, and most of those counties have done so. But for the most part, a lot of counties are shying away from jury trials. Bayfield, Barron County are the 2 counties that have had trials in my area, but the other counties, it depends on, are they having in-person? Are they primarily doing Zoom? Are they kind of shying people away, just doing felony pleas? in person. So it's kind of a county by county cross section of different people doing different things. We're also utilizing plexiglass, face shields, and masks. One of the things most counties are doing is doing health screenings when people come in the courthouse, doing the temperatures, doing the self-screening questions. So yeah, I mean, a lot of the things that the judge and that Jeff had mentioned are happening. The trial that I was a part of really focused on moving around the jury. So trying to set up the jury in the middle, jury comes in, they stay there, and kind of moving around and utilizing that to kind of stop contact between jurors, contact between other people. So, I know that there's some questions we're going to be getting into, but kind of want to reiterate some of the things that the other two panelists have talked about, but that it's kind of a hodgepodge of juries, some places, no in-person hearings, and kind of the gamut by county by county.
Great. So that's a wonderful overview of some of what's actually going on right now in 3 different jurisdictions. It looks like we have a lot of questions about jury selection. And fair cross-section and what jury veneers are actually looking like. And I know you all talked about the social distancing of jurors in the courtroom, but do any of you see trends? Judge, we could start with you if you do, but otherwise we can hear from Jeffrey and Ryan about just trends in jury, who's showing up, and jury selection issues.
Well, one of the things that I need to clarify is that the trials that we did have in our criminal department, those were trials that had already started prior to the pandemic. And then they were in abeyance, and then they resumed. So there was already jurors in place. They came back and they completed the trial successfully. The cases that came thereafter, the summons that went out, I believe a large number of summons, over 500, and maybe 100 people would show up. So some of it was COVID related, hardships, people have moved, people are ill, they've changed address, they've moved out of state. So there's all of this fluidity that's going on right now that makes it hard to really measure, and it's hard to know what we can do to close those gaps. Also, because a lot of things are now computerized, you're also assuming that everybody has the same bandwidth, that they have the same access. So those are all things that as we get closer and closer to trying cases, the judges are putting their heads together to find out how do we close these gaps, who in technology, in our technology department, can assist us in making sure that we're having a broad reach. But I am finding that people are, because they're so civically engaged now, given the climate, and some of the educational forums that have been taking place around the discussion about civil obligation. And they understand that judges and lawyers in a trial context, we can't do our job with integrity without the participation of our citizens being willing to serve, but we also have to look at our public health issue as well.
Jeffrey, do you see trends, including in what, including demographic trends, if you see any?
We do, and I actually talked with my my jury coordinator prior to this call. And I think a lot of jurisdictions have this, Professor, is we don't really get a fair cross section to begin with, and Multnomah County is a predominantly white county, and yet, like I think a lot of jurisdictions, Black, Indigenous, and people of color are overrepresented in our criminal justice system, but underrepresented in our jury pool. And what I've seen and what our jury coordinator have seen is an exacerbation of that with COVID. We summon grand jurors, 3 panels a month, so that's 21 people, but we summon 100 to get those 21. And for a typical jury service day, we ask 250 people to come in, and we're only seeing about 40 to 50 show up every day. And of those, what I've seen is a distillation of those skewed demographics, where it's the people that can afford daycare or don't have children or are retired, and also that have fewer sort of underlying health concerns. And as in my county, like I believe in a lot of counties, Black and Indigenous and people of color are overrepresented when it comes to a COVID positivity rate. So I spoke with my counterpart at the Public Defender's Office here, and we talked about the fact that, and he's raised this many times in our collaborative meetings, that what we're seeing and what we're going to see for some time is an exacerbation of our already skewed demographics when it comes to jury panel, at least a broad veneer. Well, we'll get to it later, but I think maybe this can be a stepping stone towards improving that aspect of our jury selection.
Okay, more on that later. Thanks for that appetizer.
Sure.
Ryan, thoughts on jury selection in Wisconsin?
Yeah, the two trials I was a part of, one was in late May and one was in mid-June. I was surprised how many people showed up. Our panels are usually about 50 people up here in rural Wisconsin, and we did a double panel in Bayfield, and about 55 people showed up. And I thought it would be mostly middle-aged or younger, but it was young people, it was mid people, it was old people, which I liked. I mean, in these counties, there isn't really a lot of diversity to begin with, but having that diversity of age is really important because you're going to get different perspectives and different experiences. But with the people that didn't show up, keeping those conversations with the clerk and checking in with her, it just happened to be her, of who was calling in, what ages were calling in, and really, pushing her to make sure that we had a fair cross section. Because I did have a conversation. We had multiple meetings, especially for the first trial I had. What's going to happen if we have only really young people show up, or what's going to happen if under 40 people show up, or if we excluded so many jurors and we can't there weren't a lot of people on the street in Washburn at the time. So it's like, what's the backup plan, or how are we going to deal with that? So I think having that open conversation. But in Wisconsin, I can definitely say one of my counterparts in Barron County was also surprised that people really wanted to show up and do their civic duty, as the judge had mentioned. Some of the pre-teaching, the letters that the clerks sent out about the safety protocols, having doctors and nurses on hand, I think really made people feel safe, so they wanted to participate. So I think that really helped get participation higher than I think a lot of people expected.
Thanks. A couple of the questions that we got before the webinar today had to do with how we prioritize cases, given that even if we do have jury trials, it's going to be a lower number because of how many jurors show up and all of these new procedures that have to be followed. So I know each of you has a different role with respect to this question, but if you have thoughts on how cases are being prioritized, how, to the extent there are discretionary decisions for judges and the parties to make, how are those decisions being made? If it affects charging decisions, or how are backlogs and case loads being managed given the small number of trials we can have? Judge, do you have thoughts on that?
What we did here in Alameda County in California is that our Chief Justice sent out emergency protocols and rules that we could utilize in order to assist us in downsizing our in-custody population. So we all got together, we began looking at the entire in-custody population to see who was eligible and suitable to be released, so that they would not suffer any pretrial incarceration for an extended period of time, given the COVID spread and given the COVID spread within institutions. The second thing we looked at was which cases were going to have priority based on their no time waiver status, which cases were serious and violent cases. If they were not serious violent, then we may have downgraded their custody status or downgraded their bail, or we utilize some other form of monitoring by electronic monitoring, or allowing another agency to provide us with some supervision of defendants that were not categorized as serious or violent felons accused, and would be able to once again downsize that population and then to determine whether people wanted to waive time, if they were already in a trial department and we're still trying to navigate what's going on, because some cases we're sitting in a trial department getting ready to start trial before all of this happens. So every 60 days to 90 days, the court has to make specific findings, good cause findings of why that case is not impaneling a jury, and asking for stipulations or waivers from the defendant and counsel to see if it provides some flexibility and the waiver of regularities. But even if that happens, the judge should still make very specific findings about the availability or unavailability of witnesses, travel ban issues, COVID issues. Alameda County is a very high COVID rate. All of these different things that contribute to why the court was not able to proceed with this particular trial. And then to try to handle some of those other matters, particularly preliminary hearings, where we can do some screening of cases that shouldn't have individuals in custody.
Thanks. Jeffrey, has this affected, I know you mentioned collaboration with the public defender in Portland. Has this affected prosecutorial discretion decisions?
Yes. From the get-go, we pulled our entire staff together. We've got a staff of about 80 lawyers, and the DA and I pulled our staff together. And the first thing we said was, right now, everyone increases their risk tolerance for letting people out pre-trial. And that just came from the top down. We're not going to keep people in our jail, which has not had an outbreak, although our prisons have. But we're going to sort of suck it up, and we're going to increase our risk tolerance. And then we started, talking to our lawyers about, making better deals, making better plea offers. This is a different time, and it's a different situation, and it's a little bit of a balance of victims want and need their day in court and their closure, and if they're due restitution, they need that, and that'll never go away. But we needed to start addressing our backlog before it became a huge backlog. And that's what we did. And, without the threat of a trial looming over a criminal defendant, sometimes there's less and less incentive to resolve one's case. And we get that. In the midst of all this, I got a new boss. A new district attorney took over here on August 1st. And he ran on a platform of reform, and so one would think that this dovetails nicely, and I think it will. But we've had a lot of other things going on in Portland that maybe have taken his attention away from tinkering with our plea negotiation policy. But that said, what we're looking at now is possibly implementing a diversionary type program for a lot of these people that are backlogged. For a long time, Portland was the auto theft capital of North America. I'm not sure it still is, but we have a lot of stolen cars here, and stolen cars seem, while gravely important and sometimes devastating to a victim, sort of less important in the grand scheme of things. And my counterpart of the public defender's office and I had a heart-to-heart talk about a process of offering a plea, some restitution, some programming to address underlying issues, whether it's drug use or mental health, and then with an opportunity for dismissal at the end of a specified time. Still getting everything that a prosecutor would want out of a resolution, but without the tag at the end that sticks a person with a felony conviction. And I think those conversations are going to go forward, and if they do, then that's going to be an innovative way, something that hasn't happened specifically in Multnomah County on felony cases, to clear our backlog.
Thanks.
Yeah.
Ryan, I know your role is necessarily a bit more reactive as a defense lawyer, but have you had shifts in the way that you manage caseloads or strategies, given that you have more than one client, I'm assuming?
Yeah, no, in Wisconsin, the remedy isn't necessarily a dismissal, but it's a custody to out of custody. We call them signature bonds. So a lot of courts were really open to hearing those motions to convert, cash bonds to signature bonds, and that happened really quickly. I was really surprised how many sheriffs and judges were really quick to say, okay, we have this population that has, maybe low-level felonies, just a non-appearance cash bond and a misdemeanor, go from those cash bonds to signature bonds. So I think that took care of a lot of the speedy trial issues. But I think the way that the courts were really trying to figure out what's going to try and how they're going to deal with that was felony versus misdemeanor, custody versus out of custody. We have termination of parental rights cases where people have the right to a jury trial. So is there a liberty interest involved? How long has the case been pending? One of the big things that really pushed my trial in Bayfield was witness availability. One of the witnesses wasn't available till September, so this was already set. And then, long story short, I came on board maybe a month before the trial. So I think those different multi-factors really went into play. I really can't stress enough that a lot of judges were really quick for low-level things, or even sometimes mid-level felonies, if you could show some kind of connection to the community, that they were willing to let this person out of custody. So I think that really took away some of the pressure to have the trial, and especially in counties where they still aren't having them. I think judges were really open to reassessing that as time has gone on, as we keep making these arguments, well, Your Honor, we're not having trials, you don't have a plan, or you don't want a trial. This person's sitting in custody on a mid-level felony. I think we need, and here's his mom, and now we have all these other resources for dad. So I think just trying to convince the courts and the DAs that, especially in counties that aren't having jury trials or very limited number, here's our plan that would never have flown pre-COVID, but now they're really open to, okay, show me what's going on and I'll consider it. So we've had a lot of luck with that, really, even at the prison level, having those conversations about getting people out of custody that way for COVID related issues and getting some sentence modifications. So just being creative with the statutes and convincing them that under the circumstances we have to, public health versus some of the other concerns that used to be a big deal.
Got it. Thank you. So I think I have maybe one more minute to ask a question before we open up for Q&A, but I think it's pretty fluid here. I've already suggested there's some questions that you all have already weighed in on, but one thing that I haven't asked yet that I want to make sure that we hear from you on is whether there are, well, first, what legal issues have arisen with respect to the practices that are being used to facilitate in-person jury trials, aside from fair cross-section and the speedy trial right itself, which we've talked about. But also, so maybe I can go back to that, but also what unexpected benefits perhaps there may have been in what's been happening over the past few months, and just to have one positive note here with everything going on, and maybe some practices that you foresee us holding on to even when the pandemic recedes a bit. Judge, thoughts on that?
Well, my thoughts are as follows. We've been able to live stream some of our proceedings, most of our proceedings, so the public is able to hear cases as they're being resolved and as they're being heard. In addition, particularly in a community where there is a large demographic of individuals, racial diversity, as well as economic diversity, it has really allowed people to have access to justice without having to disrupt their employment. So if it's a brief hearing, if it's an uncontested hearing, if it's a status hearing, they're able to participate remotely, take a break from work, not disrupt and lose an entire day or half a day. And that may be something we want to think about going forward as we begin to talk about the stress that we're putting on our citizens when they're accused or when they're witnesses or when the attorneys find themselves in multiple appearances. And it's an appearance that can be resolved relatively quickly and something that will streamline the process, particularly when we get back to normal, or when we get back to, really servicing all of these cases, and we are public servants first and foremost, we will have a backlog. And so if we can find ways to utilize this new technology to reduce that backlog by allowing people to resolve cases remotely and to be able to have negotiation conferences, status hearings, all of those hearings that just take up time from the actual litigation will, I think, serve us well.
Thanks. Jeffrey, thoughts?
I agree with the judge, and I think that two things. Number one, the sort of foisting upon the practitioners of this technology, like we're using today, and like I've been using in court and with my counterparts, is making us more comfortable using that technology, and I expect that to continue and to get better. I was lousy at Zoom calls in April, but I'm fairly adept at it now, and I think that a lot of my colleagues are also. And I think that that has benefits on so many different levels, like the judge said, not requiring a criminal defendant to take a half day off of work to come down for a 15-minute hearing, to park, to get childcare, all of that kind of stuff, to save litigants time, to save the court docket time. So I think that this sort of troubling situation will move our technology forward, and that's a good thing. The second thing is that I think, from the people on my side of the table, the prosecutors, I think a lot of times when change is suggested, or when different things are proposed, or when a relaxing of things like our adherence to mandatory minimums, is suggested, then the reaction is, no, the sky is going to fall if we do that. And I think this has forced a sort of reckoning among at least the people in my office, and I think the people in my state, that no, the sky is not falling because we're not seeking that mandatory minimum sentence, or because we're not so worried that a person missed a court hearing that we want to file a failure to appear charge on. So a little bit of it is just a reset, a sort of a reset that's mandated by circumstances that I think is going to have I hope is going to have benefits in the future.
Ryan, possible benefits for defendants and their families and defense witnesses?
Yeah, no, I think the flexibility of appearance has been a game changer, especially in rural Wisconsin. Transportation, that could be another Zoom webinar in and of itself, and the effects on criminal defendants and litigating their cases and representing them. But we have bail jumping in Wisconsin and failure to appear bench warrants, and that has gone, I wouldn't say down, but it's definitely helped get people to court, either Zoom or by telephone, and it's really helped with that. I think looking forward, I think sometimes witness availability is sometimes hard because you have to ask for the expense to get the witness and then to get the witness here. And I think if your client is okay with the person appearing and the judge is okay with the person appearing by Zoom, I think it's going to help widen the net for experts, again, especially in rural Wisconsin. I also think it's helped access to clients. I know, best practice is to go to the jail and meet with your client, but when you can't go to the jail, Zoom, telephone, Google Hangouts, any other telemeans is the next best thing. And I think it's really leads me to my next point, conversations that you usually wouldn't have with other criminal justice partners. I've had more conversations with sheriffs, DAs, judges, showing them, hey, this person showed up every time, but now they don't have a data plan, so they can't show up, or, just having those open dialogue conversations in a way that I just think is landing better because everyone's in the same situation with COVID. So I think really humanizing not just the public defender's office, but our clients, and really advocating for our clients, I think has become a little easier because of that evening of the playing field.
Thanks. And so I should say we have so many wonderful questions from the gallery. I can't possibly ask all 45 of them, but a number of them, Ryan, have to do with the meaningful communication between attorney and client. And so it might be that Judge Thompson and Jeffrey also have insights about this, but if I could start with you, do you see do you feel like you have meaningful access to your clients? To what extent are you able to speak with them meaningfully, virtually or otherwise? And do you feel like there's other solutions we could be trying to make it better?
Yeah, I think, it's summer right now, and I think winter's going to offer some challenges. But meeting with people in parks, parking lots, outside the office, court parking lots, just being really flexible with meeting people has been really helpful. Again, in custody, Zoom, being flexible with the sheriff. How can I see this person? With health screenings and with the defense attorney, I think really having to make that hard decision of, I'm going to put myself possibly in harm's way so that I can meet with this person and really talk about their case in a confidential way, in a rapport building way, with a lawyer-client relationship way that I think sometimes is necessary. I think one of the questions sent out was, waiving the 6 feet social distancing in trial. How close you're going to get to your client. And I really have been happy with the jail because they've told me that they're screening people, that they're taking temperatures, that they're doing what they can do in custody to keep the inmates safe, which is going to keep me safe, which is going to keep the public safe. So I think, there's that piece, but I also think as criminal defense attorneys, we really need to soul search and say, if I can't represent this person for a health reason or an age reason, should I maybe tag team the case with another attorney that is willing to do so? Is there something you can work out where you can represent that person? But I think it does take a lot of, you're here to represent this person. And I think, representing the state and being a judge is a little different because you do have that human person in front of you or on the line or, Zoom wise. So I think you really have to figure out what you're willing to do and how your office or how your practice can accommodate their constitutional rights and their ethical obligations that they're entitled to.
All right. And, happy to move on also, but Judge Thompson and Jeffrey, if you have thoughts on how this issue has been dealt with in Alameda County or Oregon, feel free to jump in.
The way it's been handled here is that we're able to put people into breakout rooms if they want to have a private conference during the court hearing. And we place them in breakout rooms where the DA and perhaps the defense attorney can be in a breakout room. Then we can do another breakout room where maybe the defense attorney and their client are in a breakout room and are able to have a private conference. And this is one of the things that I also wanted to talk about was just the rules of professional conduct. This is an opportunity for judges to kind of mentor attorneys through this. What do you have in your background? Does the witness have something in their background that could be prejudicial to the proceeding? Different protocols are going to need to be vetted, and the sooner attorneys weigh in on that and start drafting that in their in limine motions, here's some admonitions we'd like to see. Here are some protocols. What are we going to do when we need to go in closed session? What are we going to need to do when we have a witness that is, we need to have some vetting without the jury present and without the public present? And, how do we make sure that people aren't trying to interact with the jurors when they're on the witness stand and the attorneys and the judge have taken a sidebar by Zoom in a breakout room? There are all these protocols that people need to start thinking about, and they have to remember the judge is not the person who's the litigator. We're the neutral. So attorneys need to start thinking about this landscape, thinking about how they're going to handle it, but also thinking about their own professional conduct, how they're appearing in court, even if it is on Zoom. What they're advising their witnesses, what they're advising their client, whether there's some communication that's going on in the screen and we can all see it. There are so many things that we do need to make sure that attorneys are taking a much more progressive role in making sure that they're making their record and they're allowing the judge to be able to weigh in as a neutral and to be able to resolve some of these potential technological issues.
Thanks. Jeffrey, any thoughts?
I'll just be real brief. I was on a work group talking about these very issues, and I guess I'll say that I'm hopeful also that technology is going to continue to improve. We all work on a Zoom or WebEx platform right now, but I know that those companies are developing additional technologies like private breakout rooms for litigants and defendants and witnesses, so that even in the midst of a call like this, I could maybe step into another virtual arena and have a private conversation. So, I'm hopeful, although I hope that we don't need it, but if we need it, then I think that we can all count on technology evolving also.
Thanks. So another group of questions have to do with confrontation and jury assessment of witness demeanor or defendant demeanor. Judge Thompson showed us, she actually brought props today that showed us an actual screen that is different from a mask so that you could see a witness's face. But if the jurors are in the back of the room, you could imagine, I've seen defense motions arguing against masks, but also arguing about the distance between jurors and witnesses. So maybe starting with Ryan, thoughts on whether you think that there's a meaningful way to ensure confrontation rights in socially distanced trials?
Yeah, I would present, I think there's two schools of thought. I think I may be in the minority, but in my trial, the jurors, during voir dire, so voir dire in my trial took place in a gym. We were closer to the people in the quote unquote box, but everyone was wearing a mask, and we talked about it at multiple meetings before the trial. I didn't think masks were a problem. I thought that listening to their voice, seeing their eyes, their demeanor, just in their body language, I thought I could get enough feel for that witness based on what they were saying and how they were presenting. I had conversations with other people that have had trials in Wisconsin post-COVID, and they were aghast that I didn't object. And they said that the juror had face shields for voir dire, but masks for during the trial. And but the witnesses had face shields that you could see through. But I thought that based on being the first trial, I was happy that so many people showed up. I thought that the masks were fine, but I can definitely understand the other perspective that you need those shields to gauge credibility. So I think it kind of comes down to the attorney. I think it comes down to what the client wants or what the client feels. But I definitely understand that there's two schools of thought, and that some people are so pro shield that gotten very heated, text back and forth. You can't text back and forth. But that's my perspective. I think you do what I try to imagine what I would have done pre-COVID, and I pay attention more to people's voices anyway and body language than whether they're smiling or frowning. I don't know.
Okay. Jeffrey, thoughts?
I agree with a lot of what Ryan said, and I guess that I caution my lawyers to tread very carefully on this. The speedy trial right and the right to confrontation primarily lies with the criminal defendant, and we don't know what an appellate court is going to do with these issues, and the last thing that any prosecutor wants is to suffer a reversal because they were pushing the envelope on something like mask versus shield. And I actually, a lot of what Ryan said rings very true with me, but I also think that the distance issue is maybe even more critical. In our two jury trials that we've had here in Multnomah County, the juror that was furthest away from the witness was 70 feet away. And I think that you're getting a lot of diminishing returns in that regard. And you can amplify that with technology. You can have both a live witness and a big screen TV closer, something like that. These are innovations that could take place. But with all innovations, I counsel my lawyers to proceed with caution and to give a wide berth to a defense attorney's argument about these things. They're just better suited to make those arguments, and I'm not well suited to argue against a confrontation right like this. So maybe we'll get better, but I don't even really want to get better at it.
Just out of curiosity, was there a defense objection to the 70-foot distance? in that case?
There was, there was, and but it was sort of like the show must go on. Here we are. So while there was an objection, it was overruled.
Got it. Got it. Judge Thompson, thoughts on procedures that could, aside from what you already pointed out?
What we've been doing in my department well before COVID even existed is that we do have an evidence presentation system, and we also have a standalone screen as well that the district attorney office brings into the courtroom. And that has allowed people to be able to see a lot of the exhibits, some of the 3D presentations when witnesses are talking. And now it's a matter of whether you can do a split screen where you have on one side of the screen the witness who's testifying and on the other side of the screen the actual exhibit. Those are going to be some major challenges as we move forward. And again, we all are hoping that this is a moment in time and that things will go back to some normalcy. But in the meanwhile, when you have individuals in custody, we do need to keep in mind our professional responsibility, the speedy trial rights of those who are accused and not convicted, and making sure that we make it so that a cross-section of our community is able to participate both in terms of defendants' families, witnesses, as well as the public.
I think, just to jump in here, I think confrontation to me is, I'm more concerned about maybe witnesses' confrontation than voir dire. And again, I may be in the minority, but I think it's more important to have the witness be observable by the jury and by the defendant, and to have that confrontation. I know that we haven't really even gotten to virtual, like Zoom jury trials, but I think you have to have everyone in the same room for sure. So I'm more concerned about that.
So speaking of Zoom, so a number of folks have asked about the efficacy of virtual trials. It may well be that only if a defendant requests it, would it really be imposed on a defendant. And so one question, and this goes into some other questions that have been asked, what if a defendant wants to go forward to get their speedy trial with a bench trial, which they don't have a constitutional right to? They would need the courts and the government's permission generally. A 6-person jury trial, it sounds like in Louisiana that's happening to facilitate socially distanced trials, or a Zoom trial. To what extent have defendants made such requests, and do you think that there would be pushback from the prosecution or the court if those requests would be made? Is that something that defense attorneys should be doing more? Ryan, maybe we can start with you if you have thoughts.
One of the plans, and I won't name the county, but it allows for a 6-person trial. And the court, we had a back and forth on this, and I said, there's no way I'm ever going to be part of a 6-person jury trial in a criminal trial. There's just no reason. Maybe a bench trial, we go over the positives and negatives of that, and the client wants to do that. But for most of the people sitting in custody, these are, ABC felonies that are very serious. And if you're wanting a trial, I'm advising people that you have the right to this 12-person jury. If we're going to have a trial, we should at least have a procedurally as good as we can have trial. I think there's more of an appellate issue if defense attorneys start, advising people the 6-person versus 12, or I would never be a part of a Zoom trial. I think that's, you get to, and again, we're not at that question, but is this even constitutionally adequate? Is it really that fair? The judge on a previous call, we talked about, you really can't control what the jurors are doing. Are they really paying attention? I just think that there's, if we're going to have a jury trial, it has to be 12-person. It has to be in the same room. And I think anything else, I'd be very concerned about being a part of. So that's my opinion.
Perhaps we could hear from Jeffrey, and then Judge Thompson. I think you'll have the last word.
I appreciate everything that Ryan said, and I'll say this, that it wasn't a trial, but I had a high-profile sentencing that was to take place first in early March, then in late March, and it finally got pushed back to late June. And with all the logistics that we dealt with, me thinking I'm being smart and innovative, I suggested we do a Zoom sentencing. And the trial had taken a month to try, and it was big news. And I didn't expect the backlash that I got from the victims in the case. Victims want to be present also, and they're, almost every state I'm sure has at least statutory, if not constitutional, victims' rights. And like I said, I just didn't anticipate the need from a victim to be present in the presence of the defendant and a judge and a jury. So I don't see Zoom trials going forward in my county anytime soon. We do have bench trials, and defendants waive their right to appear in front of a jury, to have a trial in front of a jury, relatively routinely here. That decision is discretionary with the judge, but my office would rarely object. So bottom line is, victims would need to be consulted, and I was made to look foolish by suggesting that we have a Zoom sentencing. So I won't be doing that again.
Interesting. Judge Thompson?
Well, my final word is where I started. We can't do our job with integrity without a cross-section of the community, and that's going to require 12 people to make a decision. Our professional responsibility as jurists, as officers of the court, are to be the guardians of due process. And when we start to dilute individuals' constitutional rights for convenience, we are really running up against some real long-term issues. And it's something that's very attractive. We want to be team players. We want to participate sometimes in what we call groupthink, but it is those moments of courage where individuals are saying, let's pause for a moment. Let's be creative. Let's make sure that we're meeting and conferring, but let's not forget what our primary roles are and what it is we're supposed to be doing when the community entrusted us with these jobs.
Okay, Monica, I don't know if we're out of time. A lot of folks had questions about jury voir dire and whether in your jurisdiction attorneys are allowed to ask questions about jurors' trepidation, about COVID. Sounds like in Arizona, prosecutors are objecting to such questions. So if I had time for another question, that would be it. But I recognize that we may be out of time.
So we are out of time.
Okay.
On behalf of NACDL, NCSC, and RTI International, I just want to thank our panelists, our moderator, and our viewers for joining us for this important discussion. So CLE credit is available for those states listed. Please go to our website if you want the forms, and if you have any questions about CLE, you can email cchrisfield@nacdl.org. If you'd like to learn more about opportunities for training and technical assistance from the Justice for All Strengthening the Sixth Amendment grant, please email jfa@nacdl.org. Thanks again to everyone, and have a wonderful day.